Good morning, all of you. Welcome back to our class on Paper 2, Corporate and Other Laws. I know I had left you guys in middle. We had already done the contract of indemnity and guarantee, bailment and pledge. But because of my poor health, I could not take up contract of agency for you. And I really apologize for the same. However, today we are back. So I hope there were no concerns or queries with the previous two parts of this chapter, which was indemnity and guarantee and bailment and pledge. However, assuming that it's clear and all is well, I am proceeding with the next part, which is contract of agency. Now, the contract of agency, if you look at sections, it deals section number 182 to 238 of the Indian Contract Act. And there are a lot of areas that are really important here, which includes especially the concepts like revocation, concepts like sub-agents, substituted agents. These are the areas from where you often get to see questions in the examination paper. We have 2.5 hours today, in which I'll try my best to cover up maximum portion, rather everything that's there in your syllabus, so that nothing is left behind. However, if there is scarcity of time, I might skip one or two sections which are not really a lot relevant for the exam purpose. But I would put in best of my efforts to cover each and every topic that has been provided for in your syllabus. Okay. Now, when we talk about contract of agency, the first thing that we need to understand is the relationship between the principal and agent. So who is this agent? How is this relationship happening? So there is principal. Now the question arises who the principal is. The principal is the person for whom some work is being done. Now, either he can do the work himself. Let's say I want to buy chocolates from market, correct? Either I can right away go to the market, buy chocolate on my own, or maybe I can hire someone to go and buy it on my behalf. So when somebody does something for the behalf of the principal, that person is called the agent. And for the third party, it is the principal obligation of the principal. It is the key obligation of the principal to perform the contract. So if you see, there is a tripartite relation here. There is a direct relationship between the principal and agent. So agent is supposed to act as per the directions of the principal. Now, whatever is done by the agent, the contract that agent enters with a third party on behalf of principal, that is binding on the principal, and that will always be binding. So it becomes the principal's obligation to perform the contract. Now, what if agent makes a promise? That promise was as per the powers or as per the instructions given by the principal, but he does not fulfill his promise. In that case, principal will be liable to the third party. So even though the principal has not directly entered into a contract with the third party, there is no direct contract as you see, but because agent is a representative of principal, whatever is done by the agent is supposed to be done by the principal. So this creates a privity of contract between the principal and third party, even though there has not been any direct coordination or direct interaction there. Okay. Now, talking about the test of agency. Now, when you look at whether there is an agency relationship or not, that is ascertained when you look at two basic points. Now, the first point is whether the person has the capacity to bind the principal. So if the person has the capacity to bind the principal and make him answerable to the third party, it qualifies the test of agency. Now, whether he can establish privity of contract between principal and third parties. So as a general principle, all of you know that privity of contract only lies between two people who enter into contract, 3 people or 4 people, or the people who are parties to the contract. Here, principal is not directly entering into a contract with the third party, but privity of contract is established through agent. Correct? So these are the 2 points. If they are fulfilled, we say that agency exists. So when the person has the capacity to bind the principal and he can establish a privity of contract between the principal and the third party, then we say that it's a principal agent relationship. Now, when we talk on the contract of agency as such, it is based on two basic principles, or there are two tenets which guides the contract of agency. One, whatever a person can do himself, he can be allowed to do it through an agent, right? So it involves services like painting, marriage, singing, etc. And second important principle is whatever a person does through an authorized agent, he does it by himself. So whatever is the act of agent, it will be considered as the act of the principal. Okay. Now, here are the few examples that I put forward for you. A businessman delegates B. So who is A? A is the principal. Whom is he delegating? He is delegating it to B. So who would be B? He would be the agent to buy some goods on his behalf. Joe appoints Mary to deal with his bank transactions. So who is Mary here? Mary is the agent. Lavanya lives in Mumbai but owns a shop in Delhi. She appoints a person, Susan, to take care of the dealings of the shop. So who is Susan here? Susan is the agent and Lavanya is the principal. So whatever transactions are taken care by Susan, or whatever contract she enters into, she orders for goods, she makes payment for it. For each of it, Lavanya would stand directly liable to the third party. Okay? Is that clear? Now, the question arises, who can employ an agent, right? So, section 183 says, any person who is of the age of majority, according to the law to which he is subject, and who is of sound mind, may employ an agent. So, what are the requirements to be able to employ an agent? Firstly, the person should be of sound mind. Secondly, the person should have attained the age of majority. Is that clear? So these are the two requirements for being able to enter into a contract of agency. So always remember, this is also a kind of contract. And because this is also a kind of contract, the key requirements of the contract have to be taken care of. That is always important. Okay. Now, so what would be the result out of it? Can a minor appoint an agent? No, a minor cannot appoint an agent. So do not confuse between, there will be two concepts that we'll be doing here. One is who may employ an agent and who can be an agent. So these are two different concepts. Who can employ an agent? A person who has attained the age of majority and of sound mind. AS. Okay, so person who has attained the age of majority, or AMS, attained majority and is of sound mind, they can employ an agent. So a minor cannot appoint an agent because there cannot be a valid contract. Now, the question arises, can a minor appointed be as an agent? Yes, a minor can be appointed as an agent by a principal who has attained the age of majority and is of sound mind. Now, what will be the repercussions of it? A person who is of sound mind and has attained the age of majority, he appoints an agent who is a minor. What will be the repercussion to it? So we know that an agent is supposed to act according to the instructions of the principal. So here we have an agent who is a minor. He did not follow the instructions of the principal, because of which there was some confusion. So the principal will remain binding with the third party because he's a major and he knowingly appointed a minor. But the minor, even though he did not follow the principal's the instructions or acted negligently, he will stay unanswerable to the principal. So generally, an agent is answerable to the principal for his negligence or for not following his instructions. But where the agent is the minor, he will not stand liable. It will only be the principal who will stand liable to the third party. So let's read section 184. 184 says, as between the principal and third person, any person may become an agent. So when I say any person may become an agent, he could be a minor also. But no person who is not of the age of majority and of sound mind can become an agent so as to be responsible to his principal. So what happens here? So if a person who is appointed as an agent, he's a minor, or he's of unsound mind, in that case, he will not be responsible to his principal, but the principal will also always stand liable to the third party. So is this clear? So Vikas is asking me, ma'am, can minor be appointed as a principal? Who is appointing principal? Principal is there. Principal is the person who employs an agent. Who can employ an agent? The question was, who can employ an agent? So here when I said who may employ an agent, it is the principal who employs the agent, right? So we already discussed a principal has a majority to be able to appoint a principal. To be able to appoint an agent. Don't get confused, okay? See, Narayan is asking me, ma'am, if agent is a minor, is the principal liable? Principal is liable for every contract that is entered by the agent. He's always liable to the third party. But there can be cases where the agent does not follow the instruction of the principal. Here also, the principal will stand liable to the third party, but where the agent is a minor, agent will not be liable to the principal for not following the instructions of the principal. Is that clear? So if you read here, an agent incurs no personal liability while contracting for his principal, and therefore it is not necessary that he should be competent to contract. Thus, a person may contract through a minor agent, but the minor will not be responsible to his principal. Look at this example here. It will help you understand better. So P appoints Q, a minor, to sell his car for not less than 2.5 lakhs, right? So who is the principal? P is the principal, Q is the agent, Q is a minor. Q sells it for 2 lakh rupees. So what is happening here? Q did not follow the instruction. P will be held bound by the transaction and shall have no right against Q for claiming the compensation for having not obeyed the instructions, since Q is a minor and a contract with a minor is void ab initio. Is that clear? Is this clear now? So with this example, you could understand how it's happening. So what basically happens, there are two contracts, not technically, but somehow if you see, agent is directly entering into contract with third party. So logically, it should only be the agent responsible to the third party, correct? But where there is a contract of agency, principal, because he has appointed the agent, he stands liable to the third party. So if the agent is minor, principal will be liable to the third party, but principal will have no rights or actions against this minor agent. Is this clear now? Any confusion in this point? So two relevant points here. One, who may employ an agent? A person who is of sound mind and has attained the age of majority can appoint an agent. Who can be appointed as an agent? Any person can be appointed as an agent, even a minor. What if a minor is appointed as an agent? If the minor is appointed as an agent, principal will have no rights against the minor, but he will have all liabilities towards the third party, or whatever contract or obligations are incurred by the agent, principal will stand liable for that. Are we good till here? So, Further, there is a unique part in the contract of agency that we see. So generally, when we were talking about basic requirements of a valid contract, one of the basic requirement is that there has to be a consideration. Now, what is this consideration? Something in return of something. But in case of contract of agency, consideration is not mandatory. So how are these agents remunerated? Generally, you will see that agents are remunerated by way of commission. So let's say you are a wholesaler of ready-made garments, correct? So you appointed a person as an agent to go and sell the garments that you have at your store. Now, this person will usually be paid in terms of commission. 2% of the total sale value, 5% of the total sale value. So when we talk about contract of agency, consideration is not necessary, correct? Or immediately necessary at the time of appointment. So Justice Desai of the Supreme Court had once said that the relation of agency arises whenever one person called the agent has the authority to act on behalf of another, called the principal, and consents to act. So the relationship has genesis in a contract. Is that clear? Now, next thing that we have to see, what kind of authority or how authority is given to an agent. So there can be multiple types of authority. So one is the actual authority and second is the apparent authority. What do you mean by the word actual? So when I say actual authority, that means authority has actually been given. So today I appoint Mr. X to be my agent and go and sell clothes in the market. He's duly appointed as an agent. So what has happened? Here I have given an authority to him. So actual authority exists when the agent takes an action on behalf of the principal and he reasonably believes that the principal wants this action to be taken. Now, whenever we talk about this actual authority, it can either be express or implied. It is an express authority when it is expressly spoken or talked about. It is implied when it is implied through the actions of the principal. It is necessary for the agent to accomplish the objective of the agency. So it is a implied authority. So let's say if a person has been authorized to go and sell garments in the market, later on he comes back with few pieces who were defective. So here is the implied authority. Because he is going in the market selling of the clothes, he is the person who is in direct contract. So he will be the same person who will be getting back the defective garments as well. Okay. So because principal is the person who is hiring an agent, he can decide his authorities. He can decide the ambit of his authority. He may grant the powers or he may even take it back. Correct? So the first kind of authority that we talk about is actual authority. Now the actual authority can be an express or implied. Second is a apparent authority. Apparent authority is authority which is not expressed, but it is apparent from the actions of the party or which makes the third party believe that the agent has the authority to perform the action that has been allotted to him. So if you look at this example, principal employs agent to manage his business. Principal tells agent he can't buy more than $500 worth of goods from any supplier. Principal tells or implies to a vendor, however, that agent has unlimited authority to buy from him. So what is happening? The agent's authority is limited to $500. But what did agent do here? He told the vendor that he has a unlimited authority and accordingly he buys 1,000 worth of goods from the vendor. Now, what has happened? Here, the agent has the apparent authority to make this purchase because the vendor believed believed in the actions of the agent based on the principal's conduct. So here, what will happen? principal will stand bound for the action that has been taken by the agent. Is that clear? Okay. So when we talk about types of authority, there are two kinds of authority. One is actual authority. Second is apparent authority. Actual authority is actually the power given. Apparent authority is the authority which is believable by the third party based on the actions of the principal and the agent. Correct? Now, these authority can either be express or implied. Express is when it is categorically said or given. Implied can be based on the circumstances of the case or based on the actions of the parties. Now, next topic that we talk about is modes of creation of agency. How is this agency created? What are the different ways through which the relationship of principal and agent is created? Please mark this topic as important. You get to see a lot of questions from here, especially from Estoppel, necessity, ratification. You get to see a lot of questions. So please mark this topic as important. Yes, Narayan, even though buying goods for 1,000 rupees was beyond the power of agent, but here we were not discussing the implications of agent doing something which is beyond his power. We are saying we were talking about apparent authority. Apparent authority is when the principal agent, through its conduct, make the other party believe in the authorities. So even though he is exceeding the authority, the principal will always stay bound. Later on, principal can recover his amount or the losses that he has suffered from the agent. That is a separate story. All I was trying to explain is the concept of apparent authority and actual authority. Is that clear, Narayan? Okay. Now, the first mode of creation of agency is by express appointed. So where a person is expressly appointed as an agent, it is called an appointment by express agency through express appointment. Like, let's say, as chartered accountants, a lot of times you go and represent your client in front of tribunals, correct? What do? The client gives you a authorization letter. He puts down a letter where he expressly authorizes to you to go and represent you in front of a IT tribunal or a GST tribunal, right? Taxation tribunals. So what has happened here? It is a express appointment, correct? So look at these example here. A is residing in Delhi and has a house in Kolkata. A appoints B by a deed called power of attorney as a caretaker of his house. So agency is created by an express agreement. So where there is a power of attorney, the authorities or the ambit of the powers of an agent are clearly defined. So when you look at lawyers also, what do? They submit wakalatnama in court. What is this wakalatnama? It is nothing but a power of attorney. So if you ever get to read wakalatnama, you will always see that it says to act, to plead in front of the court of law and things like that. Correct? So there is a express appointment here. If you look at another example, if a customer of a bank wishes to transact his banking business through an agent, the bank will require written evidence of the appointment of the agent and will normally ask to see the registered power of attorney appointing the agent. Also, you see these cases when, let's say, you have a lot of properties in India, but you are permanent resident of US. It's not possible for you to keep coming to India. And you need somebody to manage your properties here. So what do? You appoint a registered power of, you appoint an agent through a power of attorney. So you sign a POA. Through POA, you allocate your rights to an agent. So whatever rights he has been given, whatever powers he has been given, he can act accordingly. So is this clear? Agency by express appointment is clear to everybody? Any confusion here? Okay. Now coming to agency by implied authority. So when we talked about express, they have been expressly granted through an agreement. Here, they can be implied from the circumstances of the case, by the conduct of the party, by the things spoken or written in the ordinary case of dealing. So if you look at this example, if a person realizes rent and gives it to the landlord, he impliedly acts for the landlord, correct? As an agent. So there may be situations where where a person has not been expressly appointed as an agent, but from the circumstances, from the conduct of the parties, it is evident that he is acting as an agent. So let's say A owns a shop in Selampur, living himself in Kolkata and visiting the shop occasionally. The shop is managed by B, and he is in the habit of ordering goods from C in the name of A for the purpose of shop and of paying them out of A's fund with A's knowledge. So what has happened here? B has an employed authority from A to order goods from C in the name of A for the purpose of the shop. So it's very basic and simple. Express appointment, implied appointment, very basic. Third important point is estoppel. Now, what is meant by estoppel? Can anybody tell me what is meant by estoppel? All of you can put your answers in chat box. What is meant by estoppel? I'm waiting to hear from all of you. What do you understand when you say agency by estoppel? Or what is the concept of the principle behind estoppel? I think all of you have read this in your foundation part, and concept of estoppel is something very basic. I'm sure all of you already know about it. I'm waiting for your answer, kids. Please tell me. Nobody knows? So Pooja is saying person not actually but representative himself. No, incorrect. Anybody else who understands the concept of estoppel? Let us look here. So the principle of estoppel says that when one person by declaration or representation, or there has been some action or there has been some omission, has intentionally caused or permitted other person to believe a thing to be true and to act upon such belief, he shall not be allowed to deny his previous statement, or he shall be stopped to deny his previous statement. Correct? This is called the concept of estoppel. So let's say today I go to market for buying goods for my shop. I take a friend along with me. So, okay, I'm here in Delhi, but I have gone to Kolkata for buying some goods, and there I have taken a friend from me. There, whichever shop I go for purchasing goods for my shop, I always tell that he's my friend, he will be taking care of business further. He is my friend, he will be purchasing the goods further. So later on, I cannot go and say that this friend of mine has nothing to do with my shop or with the purchase. So whatever the obligations, I can later on inform all the parties when that relationship with my friend is broken. But till then, whatever obligations will be incurred by my friend, it will be treated as my obligation. Correct? So let us have a look at section 237 of the Act. It says, when an agent has, without authority, done acts or incurred obligation to third person on behalf of his principal, The principal is bound by such act or obligation if he has, by his words or conduct, induced such third person to believe that such act and obligation were within the scope of agent's authority. Correct? So let's say the agent's authority is limited to buying goods up to ₹1,000. Correct? But my agent went out in the market and purchased goods worth ₹5,000. When I spoke to the seller of these goods, I never mentioned that the authority of the agent is limited to 1,000, or I do not raise any concerns over it. So what has happened? There is a estoppel happening. Through my conduct, I have made the third party to believe that the scope of authority of this agent is not limited. So this is how the agency by estoppel is created. Is that clear? Estoppel can get into picture, but this will be only when the parties through their conduct let the other party know that it is the obligations that are under being taken by the agent are the valid obligations. So is this section 237 clear to all of you? Please let me know. I would request all of you to read this once more so that there is no confusion. So the principle of estoppel lays down that when one person by declaration, representation, act or omission has intentionally caused or permitted another person to believe a thing to be true. So when you through your actions or conduct make other party to believe that this particular thing is true, then you cannot jump back from that. You will have to honor the obligations that you have incurred through your conduct. This is all about agency of estoppel. So when you look at section 237, there are few essentials to be fulfilled. First, principal must have made a representation, right? The representation may be express or implied. The representation must state that the agent has an authority to do certain act, although he has no authority. So in reality, agent does not have authority, but the principal through his representation, through his conduct, has made the third party to believe that the agent has authority. The principal must have induced the third person by such representation, and the third person must have believed the representation and made the contract on belief of such representation. Correct? So he should have believed in the conduct of the principal and accordingly entered into certain contracts. Now where the principal, where the third party had knowledge of non-existence of agency, then he cannot claim benefits here. He will not be able to force the principal to honor his obligations because he has knowledge. So one of the important ingredient is that the third person must have believed the representation and should have made the contract on the belief of such representation. Is that clear? So these are the key ingredients that need to be fulfilled. Look at this example here. A consigns goods to B for sale and gives him instructions not to sell below a fixed price. Correct? So who is the principal here? A is the principal, B is the agent. Then C, being ignorant of B's instructions, enters into a contract with B to buy the goods at a price lower than the reserve price. A will be bound by the contract. A cannot plead that he had given B instructions not to sell goods below certain price because agency of estoppel will operate here. Another example is If PL has for several months permitted Sunil to buy goods on credit from Prasad and has paid for the goods bought by Sunil, PL cannot later refuse to pay Prasad, who had supplied goods on credit to Sunil, in belief that he was PL's agent and was buying the goods on behalf of PL. Again, PL will be stopped from asserting that Sunil is not his agent, because earlier, through her conduct on several occasions, he had made the third party believe that Sunil is the agent of PL. Is this clear? So, in this case, which is Pickering versus Busk, a purchaser of hemp allowed it to be remain in the custody of the broker through whom he had bought it. So the broker's ordinary business was to buy and sell hemp. He sold the hemp and received the price. So what has happened? There was, so the broker's general business was to buy and sell hemp. He was in the custody of hemp of some other person, but it was valid for him because the other person will not be liable here because he believed that he's in the business, so it was fine to buy. Next is, if you the court held that the sale and receipt of money was binding on the principal. Lord Ellenborough explained the principle and said, if a person authorizes another to assume the apparent right of disposing of property in the ordinary course of trade, it must be presumed that apparent authority is the real authority. He may bind the principal within the limits of the authority with which he has been apparently clothed by the principal, and there can be no safety in commercial transaction if he could not. So don't get into all these case laws. This is only for you to help you understand. All you need to understand how the agency by estoppel is created and what are the key ingredients of section 237. Is that clear? Any confusion with agency by estoppel? Agency by estoppel is clear to all of you? Please say yes or no. It's a very important topic. Agency by estoppel is a very important topic. Next is agency by necessity. So when you hear the word necessity, what comes to your mind? A relationship that is being created out of necessity in emergent situations. So what could be those emergency situations? Let's say I'm sitting in my office right now, correct? Now, there can be a case where I'm not in my office, but my office team is, right? So there are a team of 8-10 people who is there in the office, but I'm not there. Who is the owner of the office? I'm the owner, so I'm the principal. Now, all of a sudden, there is some sort of short circuit in the office, and one of the team lead takes necessary steps to prevent destruction in the office. So what has happened here? He has become an agent by necessity. So if he calls if he gets a tanker of water to dispose fire and he incurs cost for it, he has become an agent by necessity because it was important to extinguish the fire. Correct. So an agency of necessity arises under emergent circumstances. So where an agent is authorized to do certain act, and while doing such an act, an emergency arises, he acquires an extraordinary or special authority to prevent his principal from loss. So if you look at this example here, Raja has a large farm on which Shyam is the caretaker. When Raja is in Canada, there's a huge fire on the farm. Shyam becomes an agent of necessity, and whatever expenses he incurs in order to protect his principal, the principal will be bound and will be liable to pay for those expenses. So because these expenses were incurred to prevent destruction of the farm or to prevent loss to be caused to the principal. So this is the agency by necessity. Is this clear? Agency by necessity is clear to all of you? Please let me know if agency by necessity is clear to all of you. What do you understand by the word ratification? To ratify is to affirm or to approve on something. So this is a word that you often come across in Companies Act also. So when something is done by a person without your knowledge, but you later on approve those actions or omissions, that is called ratification. So section 196 says, where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts. If he ratifies them, it will have same effect as if it was performed with authority. So ratification is nothing but approving a previous act or transaction. So if an act, even if it was done without authority, but if it is ratified, it becomes valid. And ratification can again be either express or implied from the conduct of the party. So look at this example here. X, who is Y's agent, has on 10th January 2019 purchased goods from Z on credit without the permission. After the purchase on 20th January, Y tells X that he will accept responsibility to pay for the purchases, although at the time of purchase, the agent did not have the authority to buy on credit. So by saying that I agree to pay for the goods that have been bought on credit, he has ratified the actions of his agent, which were beyond authority. Correct? So section 197 says, ratification may be expressed or may be implied in the conduct of person on whose behalf the acts are done. So it is expressed when it is categorically accepted. It is implied when it is implied through the conduct of the party. Is that clear? Now, another important thing for a valid ratification. So what happens in ratification, that a person is approving an act of an agent. So the agent has undertaken some actions, he has done something or he has omitted to do something. Those action of them was beyond authority, but the principal is ratifying it, is later on accepting it and is giving it a validity, correct? Now, to be able to give a valid ratification, knowledge is a must. A ratification that has been obtained by misrepresentation or by hiding of important facts, it is defective. So if you look at this example here, A has an authority from P to buy certain goods at the market rate. He buys at a higher rate, but P accepts the purchase. Afterwards, P comes to know that the goods purchased by A for P belonged to A himself. So what has happened here? There was not full knowledge of the facts. So here the ratification will not be binding on P, who is the principal here. So the ratification becomes binding on the principal only when he has full knowledge of the actions. He has full knowledge of the material circumstances, on the material facts, or on every information that could have affected the decision of the principal. So we are reading these things because later on we get to see that in these kind of relationships, there are commercial transactions and there are liabilities that are being incurred. So when there are liabilities that are being incurred, it is important to understand these important key areas that help to create a valid ratification. Are we good till here? Any confusion till here? So Tanu is asking me, ma'am, if a principal chooses not to ratify, then if he chooses not to ratify, then the principal will not be bound. But there could be another situation where the principal, through has his conduct, made the third party believe that he is the authorized agent. Then the situation will be difficult. But if everything is common, where there is no estoppel, there is no necessity, and something is done by the agent which is beyond his authority, and the principal chooses not to ratify, then in that case, he will not be bound by the actions of the agent. Is that clear? Now, what happens when a person ratifies an unauthorized act? So, whenever there is a ratification of an unauthorized act, the entire transaction will be ratified. Ratification can never be done in parts. A principal cannot ratify what is beneficial to him and reject what can cause loss to him. So, whenever there will be a ratification of transaction, it will be a ratification in whole or in its entirety. Correct? The next is ratification of unauthorized act cannot injure third person. So when I say ratification of an unauthorized act cannot injure third person, it means we cannot ratify something which has or which creates the implication on a third party or which can in any way affect the rights or liabilities of the third party. So section 200 says an act done by one person on behalf of another without authority. So what is there? There are two people, principal and the agent. The agent has done something, but whatever he has done it without authority. So if you read here, an act done by one person on behalf of another without such other person's authority, which if done with authority would have the effect of subjecting a third person to damages or of terminating any right or interest of a third person, cannot by ratification be made to have such effect. So if the action is such that it affects the right of a third party and that action has been taken without the authority, it cannot be ratified. The principle of ratification does not apply in such cases. So if you look at this example, A, not being authorized to by B, demands on behalf of B the delivery of a chattel, right? So A, who is A? A is the agent. Who is B? B is the principal. So what is agent doing? He, on behalf of the principal, is demanding the delivery of a chattel, which is a property of B from C. So C is the person who is currently in possession of this chattel. Now, this demand cannot be ratified by B because C will be liable for damages for his refusal to deliver. Next is A holds a lease from B, terminable on 3 months notice. C, an unauthorized person, gives notice of termination to A. So, because he was unauthorized and termination of the lease will affect the rights, in that case, this cannot be ratified so as to be binding on A. Is this clear? This concept of ratification of unauthorized act, is it clear? Ratification is to authorize something which was done beyond the authority. So let's say today you go, let's say today I have 10 team members in my office, right? Now, what are they supposed to do? Because they are in a CA firm, they are supposed to do act like file GST returns, file income tax return, go through tax audits, prepare balance sheets, right? P&L statements. This is the kind of act that they are supposed to do, correct? Are they supposed to buy groceries for my house? No. What if one of the team member goes and buys some grocery for the office? It is beyond his authority, but I can choose to accept what he has bought and pay for it to the shopkeeper. So when he reaches at the shop, he purchases the goods and then calls me for payment, or he makes the payment on my behalf. So I have the choice to either authorize to accept this unauthorized act or deny it. So when I accept the unauthorized act, it is called ratification. Is it clear, Srishti? Ratification you get to see in you must have read this word in Companies Act also. Is this clear? Is this clear, guys? Another important essential is that ratification has to be done within reasonable time. Ratification has to be done within a reasonable period of time, and it has to be communicated to the other party, and it is only the valid act that can be ratified. Any act which is illegal cannot be ratified. Correct? Is this clear? So what are all the essentials of valid ratification? 1, ratification may be express or implied. Complete knowledge is important to give a valid ratification. Ratification cannot be given for an act which can affect the rights or liabilities of a third party. Ratification always has to be done as a whole or for the complete transaction, not a part of transaction. It has to be done within reasonable time. It needs to be communicated to the other parties, and only the legal acts can be ratified. So these are the essentials of a valid ratification. Is that clear? Are we good till here? Please say yes or no. Okay, Karishma, whatever your request is, the needful will be done. Don't worry about it. Srishti, to you, the ratification is clear now. Joyce, I have got your query on ratification. Please say yes or no, Srishti. Okay, let's proceed further. Now, talking about the extent of agent's authority. So, authority of an agent means his capacity to bind the principal to third party, because here the principal is not directly interacting with the third party. It is the agent who is interacting on his behalf. So, what will be the extent of the liability of the principal towards the third party? That is dependent on the extent of agent's authority. So, agent can bind the principal only if he acts within the scope of authority. If he does something beyond the scope, either it needs to be ratified, or the principal through his conduct should have made the other party believing in this authority. So, estoppel and ratification are different things. Do not mix here. Those are exceptional circumstances or other scenarios, but generally it is the agent can bind the principal only if he acts within the scope of his authority. Anything which is done beyond the scope of his authority will not bind the principal. This is the general principle. But yes, ratification, estoppel, necessity, these are other scenarios where agency can be created. Okay. Now, the extent of an agent's authority, whether that authority is expressed or implied, it is determined based on 3 factors. First is nature of the act or the business he is appointed to do. What is the act? What is the objective? What is the purpose for which he has been appointed. So let's say you appoint a person to paint your house. So the agent will have the right to do everything necessary to paint the house. So does this mean that he is liable only to paint and not to even the surface of the wall? So if you understand the painting process, the first step always involves putting a putty on it and then a primer. Right? So putty is nothing, it is evening of the surface of the wall. So when we talk about the extent of agent's authority, it is determined on the first thing that is relevant here is the nature of the act or the business for which he is appointed to do. Second is things which are incidental to the business are usually done, or things that are usually done in the course of such businesses. Correct? Next is the usage of trade or business. Correct? So let's say I have team members in my office, even though they are chartered accountants or they are interns, it is authorized, it is impliedly authorized for them to go and meet some client or to go and collect some document from the client as well. So the extent of agent's authority will be dependent on the nature of the act or the business he is appointed to do, things which are incidental to the business, and usage of trade or business. What is the custom or of such businesses? All of these three areas become relevant in determining the extent of the agent's authority. Is that clear? Now, so whatever is the nature of agent's authority, it will always include to do every lawful thing which is necessary for carrying out the purpose. Correct? So the agent was appointed for a purpose. So anything which is necessary to do to achieve the objectives of those appointments, to do everything lawful which is necessary to achieve the objectives, that will be permitted. He is permitted to do every lawful thing justified by various customs of trade. And where the situation is an emergency situation, he can do everything to protect the principal from loss, as would have been done by a person of ordinary prudence or intelligence in similar circumstances. Correct? So he is supposed to do everything which is lawful to attain the objective, to do things which are custom to the trade, and to do everything in emergency situations that is required to prevent the principal from loss. Is that clear? Is that clear? So if you talk about the extent of agent's authority, you can see there are two circumstances here. One is the normal circumstances and second is the extraordinary circumstances or the emergency situations. So in the normal circumstances, he will do every lawful thing which is necessary to achieve the objectives of the agency. But in the emergency situations, he can do extraordinary things as well to save the principal from loss. So section 188 says, an agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. An agent having an authority to carry on a business has authority to do every lawful thing necessary for the purpose, or usually done in the course of conducting the business. So if you look at this example, A is employed by B residing in London to recover at Mumbai a debt due to B. A may adopt any legal process necessary for the purpose of recovering debt. Second is agent's authority in an emergency situation, which is provided for in section 189. But whenever agent is acting in an emergency situation, there are few important conditions that needs to be satisfied. Firstly, agent should not be in a position to communicate with the principal in the time available. There should be an actual and definite commercial necessity for the agent to act promptly. Second, agent should have acted bona fidely for the benefit of principal. he should have acted reasonably and taken practical course of action. And he should be in possession of goods that is belonging to the principal and which are the subject of contract. So when the agent is acting in an emergent situation, he can do anything to prevent his principal from the loss. Is that clear? So are we good till here? Any confusion, guys, till here? Please say yes or no. Yes, Rakesh, can agent definitely an agent can definitely collect cash on behalf of principal. There's nothing illegal in collecting cash, but when we talk about black money, then it becomes an illegal act. So any agent can do anything which is legal. See, we have, if you see practically, we have agents for all sorts of work, but the liabilities become different when it is a legal act and when it is an illegal act. If agent does something which is illegal, he will not be able to bind the principal, right? Okay. So I think we are good to proceed further. Next is sub-agent. Who are the sub-agents? So if you generally try and understand who is the agent, agent is the person who is appointed by the principal to do an act on his behalf. So what has happened here? Principal has delegated some of his responsibilities and tasks to him, right? So as per law, a person who himself has been a delegate cannot further delegate. So basically the logic here is that the delegatus non potest delegate. A person who is himself is a delegatee, he cannot further delegate. So section 190 says an agent cannot lawfully employ another to perform act which he has expressly or impliedly undertaken to perform personally unless by the ordinary custom of trade or a sub-agent may, or from the nature, designer will just design the dress for you, or you would want a stitched dress. So if you go to a boutique, the lady there, she designs it for you and she gets it stitched by the tailor. So what is happening? Tailoring is done by some other person and designing is done by other person. But do you interact with the tailor? No. You interact only with the owner of the boutique. Hello, auntie, I need a dress with this length, with this, like this and that, with the specification. You want a dress made, so you have created that agency or you have hired that lady to stitch a dress for you. This is not necessarily an agency relationship, but I'm just trying to explain you customs or exceptional situations where then can be sub-agent. So when you hire a lady to stitch a dress for you, it is not a relationship of agency, but I'm just using it to be able to explain the concept of ordinary custom. So when you request that lady to get a dress for you, stitch a dress for you, she herself doesn't stitch it. She gets it stitched under her instructions by a tailor. So what has become here? As per the customs of the trade, she will delegate the tailoring work to somebody else. So similarly, as a general principle, an agent cannot appoint a sub-agent. He cannot sub-delegate the work that has been given to him. But as per the ordinary customs of trade, there can be situations where a sub-agent is permitted. Is it clear? So section 191 says a sub-agent is a person employed by and acting under the control of the original agent in the business of agency. Correct? So let's say I am residing in Kolkata. I appointed an agent in Delhi to purchase fabrics from Selampur. Correct? Now, this agent of mine, he himself, instead of directly going to Selampur himself, he further appoints a person who is a local of Selampur to purchase the fabrics and send it across. So here the sub-agent, who is the sub-agent? He is an agent employed by the agent. So the original agent who was appointed by the principal, he further appoints an agent. So such a person is called a sub-agent. Correct? So as such, appointment of sub-agent is not lawful, but there can be exceptional circumstances where they can be appointed. Is that clear? Now, even though it is not permitted under law, there can be some exceptions to appointment of sub-agents. What are those exceptions? One is where the appointment of sub-agent has been provided for or has already been contemplated at the time of, in the terms of appointment of the agreement. Second situation is the customs of the trade permit appointment of sub-agent. Third situation is there is an unforeseen emergency which requires him to delegate the authority. So there are three exceptions to appointment of sub-agent. First, it is valid in the terms of appointment originally contemplated. Second, customs of the trade permitted. And third, if there is an unforeseen emergency which makes it necessary for agent to delegate the authority. Under these three circumstances, appointment of sub-agent will stand valid. Correct? Now, where a sub-agent is properly appointed, in that case, how will things function? So we are talking about situations where a sub-agent has been properly appointed. So section 192 says, where a sub-agent is properly appointed, the principal is bound by and responsible for his acts as if he were an agent originally appointed by the principal. So what is happening? Where the sub-agent has been properly appointed, even though he is appointed by agent, the principal will be bound by the act of sub-agent. Right? Second is, the agent is responsible to the principal for the act of sub-agent. So if sub-agent does something wrong, agent will be answerable to the principal. Third case is sub-agent's liability to principal. Is sub-agent answerable to principal? He is responsible for an act to the principal? No. Sub-agent is only answerable to the agent, except in case of fraud or willful wrong. So there are three things here. Let me draw it for you. So there is a principal, correct? Principal appoints the agent appoints a sub-agent, and there is obviously a third party, correct? Usually what happens, whatever agent does on behalf of the principal to the third party, principal is bound by it. Now we are talking about a situation where a sub-agent has been validly appointed. When the sub-agent is validly appointed, sub-agent is answerable to the agent, correct? But principal will be liable to the actions or the obligations incurred by the sub-agent on behalf of the principal. So towards the third party, principal is liable. The question arises, is sub-agent directly answerable to the principal? No. Sub-agent is answerable to the agent and agent is answerable to the principal. But there can be exceptional circumstances. What is that exception? Where there is a fraud or willful wrong. Is this clear now? Is the concept of sub-agent clear here? Is it clear? Next situation is agent's responsibility for sub-agent appointed without authority. So in 192, we were talking about situations where sub-agent was duly appointed. Here we are talking about situation where sub-agent has been appointed without authority. So it is an invalid appointment. So where an agent without having authority to do so has appointed a person to act as a sub-agent, the agent stands towards such person in the relation of a principal to an agent and is responsible for his acts both to the principal and third person. So when the sub-agent was duly appointed, principal was liable to the third party. But when the sub-agent is not duly appointed, it is the agent who will be liable for the acts of sub-agent to the principal and to the third party both. Principal will not incur any liabilities towards the third party or the liabilities that have been incurred by a invalidly appointed sub-agent. Further, the principal is not represented by or responsible for the act of sub-agent, and the sub-agent is not responsible to the principal. So there is no relationship between the principal and the sub-agent. Neither principal is liable for the action of sub-agent, nor the sub-agent is answerable to principal. He is only answerable to the agent. Is that clear? So this is all about the concept of sub-agent. So next concept that we have to pick up is substituted agent. So before we pick up with substituted agent, we can take a 5-minute break here, and then we will proceed further. So we'll take a 5-minute break. In the 5-minute break, you can revisit what we have discussed, and then we will start with the topic of substituted agent. Okay? It's 10 minutes. Okay, welcome back to the class, all of you. Hope all of you also like the break just the way I like it, because it's really important to break the monotony. I really miss the physical classes, but it's so much fun to have students in front of you and interact with them directly. Anyways, so concept of sub-agent is clear to all of you. Please read sub-agent properly. Sub-agent, substituted agent, these are important topics. We get to see questions from these areas in your exam. So next thing that we talk about is substituted agent. So understand the difference in terminology. One was sub-agent. Sub-agent is the agent of the agent. Substituted agent is when an agent is replaced by another agent. There is a replacement happening, that is a substituted agent. So if you see here, substituted agent is a person appointed by the agent. Sorry, by mistake I used this thing. So substituted agent is an agent appointed by the agent to act for the principal in the business of agency with the knowledge and consent of the principal. So where this person has been appointed with the knowledge and consent of the principal, he is called a substituted agent. So substituted agents are not sub-agents. They are the agents of the principal. So a sub-agent was the agent of the agent. A sub-agent is never answerable to the principal. He is answerable to the agent. But substituted agents are the agents of the principal, where the principal appoints an agent, and if that agent identifies another person to carry out the acts ordered by the principal, then the second person is not to be treated as sub-agent, but only as an agent of the original principal. So if you read section 194, it says, where an agent holding an express or implied authority to name another person to act for the principal in the business of agency, and he has named another person accordingly, such person is not a sub-agent but an agent of the principal for such part of the business of agency as is entrusted to him. So if you look at the business of clothes selling, you might require that there is a person who is for purchasing the goods. Then there is another person who is for selling the goods, right? So there can be situations where a person is duly appointed by the agent to act in business of agency. So let's say Mr. B was appointed as an agent to take care of the business. Now this Mr. B is sitting in the shop, but he needs somebody to go and run around in the market. So who this person will be? He will be a substituted agent and not the sub-agent. So he is the person who is appointed to act for the principal. So if you look at this example, A directs B, his solicitor, to sell his estate by auction and to employ an auctioneer for the purpose. B names C an auctioneer to conduct the sale. So here the auctioneer will not be a sub-agent but a substituted agent, or he will be A's agent for the conduct of sale. A authorizes B, a merchant in Kolkata, to recover the money due to A from C and company. B instructs D, a solicitor, to take legal proceedings against C and company for the recovery of money. So again here D is not a sub-agent but a solicitor for A. So this is how it goes. Is this concept clear of substituted agent? So if you read section 195, it says, it talks about the duty of agent when he is naming such a person who will be appointed as an agent of the principal. So in selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would do would exercise in his own case. And if he does this, he is not responsible to the principal for the act of the agent or for the negligence of the agent so elected. So when the agent is appointing this person, he has to act with ordinary prudence. In that case, he will not be liable for the actions or negligence of this substituted agent. So this concept between sub-agent and substituted agent is clear to all of you. In case of sub-agent, the sub-agent that has been appointed, he is answerable to the agent. But where it is a substituted agent, he is answerable to the principal, and the agent is not liable for its act or negligence. Is this clear? So here we have given the difference between sub-agent and substituted agent. So a sub-agent works under the control and direction of agent. Substituted agent works under the instruction of principal. In case of sub-agent, agent not only appoints a sub-agent but also delegates to him a part of his own duties. In case of substituted agent, the agent does not delegate any part of his task to a substituted agent. There is no privity of contract between the principal and the sub-agent, but when we talk about privity of contract, there is a privity between a principal and a substituted agent. So substituted agent is answerable to the principal, and principal is liable for his actions. The sub-agent is responsible to the agent alone and is not generally responsible to principal. A substituted agent is responsible to the principal and not to the original agent who appointed him. In the sub-agent, the agent is responsible to the principal for the act of sub-agent, but when we talk about substituted agent, the agent is not responsible to the principal for the act of substituted agent. A sub-agent has no right of action against the principal for remuneration, but a substituted agent can sue the principal for remuneration. Sub-agents may be improperly appointed. Substituted agents can never be improperly appointed. And in case of sub-agent, the agent remains liable for the act of sub-agent as long as sub-agency continues. But in case of substituted agent, the agent's duty ends once he has named the substituted agents. And when he is naming the substituted agents, he has to act with a manner of ordinary prudence. He will have to take all the reasonable precautions just the way he would have done if he was appointing the agent for himself. So this concept of sub-agent and substituted agent is clear to all of you? Please say yes or no. Are we good till here? The next topic that we talk about is duties and obligations of an agent. So if you try and understand this relationship, you will see that agent is a person who is being appointed to do certain tasks on behalf of the principal. So what will be his first duty is to execute the mandate, that is to perform the work for which he has been appointed, correct? So the first duty of an agent is to execute the mandate. So in Pannalal Jankidas versus Mohanlal, in this case, a commission agent purchased goods for his principal and stored them in a godown pending their dispatch. The agent was under instructions to insure them. He actually charged the premium for insurance, but failed to insure the goods. The goods were lost in an explosion in Bombay Harbour. The agent was held liable to compensate the principal for his loss minus the amount received under the Bombay Explosion Compensation Ordinance. So he ended up compensating for the loss that was incurred by the principal because he did not complete the task which was allotted to him. He did not perform the work for which he was appointed. Correct? Next is, whenever this agent is executing the mandate, he is supposed to act on the instructions of the principal and be guided according the customs of the trade. He always has to act reasonable, take due precaution, take due care and attention, and be reasonable in his actions. Plus, he has to follow the directions of the principal. So if you look at this example here, A, an agent engaged in carrying on business for B, in which it is a custom to invest from time to time at interest the money which may be in hand, omits to make such a investment. So here what has happened? Agent has failed to invest the money. Now the investment of money at hand is the custom of the trade. In that case, the agent will have to compensate the principal for the loss of interest that would have been obtained by such investment. B, a broker in whose business it is not the custom to sell on credit, he sells the goods on credit to C, whose credit at the time was very high. C, before payment, becomes insolvent. So what has happened? It is not the custom of the trade to sell goods on credit. The person to whom the goods were sold on credit already had a lot of credit, means a lakh rupees of credit was already overdue. He further gave credit of 2 lakh rupees. And before this Mr. C could make the payment, he turned insolvent. So here the agent will have to compensate, or he will have to make good the loss that has been caused to his principal. So this is why he has to follow the instructions of the principal, and he will be guided by the customs of the trade. He will have, when there is no directions from the principal, he will be guided by the customs of the trade. Correct? The next duty is the duty of reasonable care and skill. So whenever agent is doing anything on the behalf of principal, he has to exercise reasonable care and skill, reasonable diligence, which is expected from the person who is in a similar position. Correct? So if you look at this example, A, a merchant in Kolkata has an agent B in London to whom a sum of money is paid on A's account with orders to remit. Right? B retains the money for a considerable time. A, in consequences of not receiving the money, becomes insolvent. So B will be liable for the money and interest from the day on which it ought to have been paid. Correct? Similarly, if you see this example, A, an agent for the sale of goods having authority to sell on credit, sells to B on credit without making proper and usual inquiries as to solvency of B. When that sale took place, Mr. B was insolvent. So what happened? This agent did not exercise reasonable care and skill. He did not put in reasonable diligence. So here he will become liable to the principal and he will be answerable for his failure. The next duty is to communicate with the principal. So whenever there is some situation of confusion, some areas where some decision has to be made, it is the responsibility of the agent to communicate with the principal and obtain his instructions. Only where there is an emergency situation and the situation is such that he has no time to communicate with the principal, only then he can rightfully exercise his right to protect the principal from loss. So this is where agency of necessity comes into picture. So as a general principle, wherever there is a situation of conflict or some decision needs to be taken, it is the responsibility of the agent to communicate with the principal and to take his instructions. Is that clear? Next is duty to avoid conflict of interest. So as such, he is not supposed to deal on his account. When he's an agent, he has to behave as an agent. He cannot go on projecting himself as the principal or the due owner. So what happens when the agent deals on his own account in the business of agency without principal's consent? That has been provided for in section 200
215. So section 215 says, if an agent deals on his own account in the business of agency without the consent of his principal and acquainting him with all material circumstances which have come to his own knowledge on the subject, the principal may repudiate the transaction. So what happens if he deals on his own account without the knowledge of principal, without the consent? The principal may repudiate the transaction. He may cancel the transaction if the case shows that material fact has been concealed from him by the agent, or that the dealing of agent have been disadvantageous to him. So if you look at this example, A directs B to sell A estate, okay? B buys the estate for himself in the name of C. What has happened? He is dealing in the own account. A, on discovering that B has bought the estate for himself, may repudiate the sale if he can show that B has dishonestly concealed material fact, or that the sale has been disadvantageous to him. So it is the duty of the agent to not to deal in his own account. If he deals on his own account, the principal may repudiate the transaction. When can he repudiate the transaction? If the agent has concealed material fact, or that particular transaction was disadvantageous to the principal. Is that clear? Are we good till here? Are we good, guys? Next is principal's right to benefit gained by agent dealing on his own account in business of agency. So we are talking about a situation where the agent has dealt in his own account and there is some profit that has been generated. So where the agent, without the knowledge of principals, deals in his own account, then the principal has a right to claim from the agent any benefit that has resulted to him out of that transaction. So if you look at this example, A directs B, his agent, to buy a certain house for him. B tells A it cannot be bought, but he buys the house for himself. So what did he do? He told the principal that the house could not be bought, but he bought the house for himself. So if later on, if he gets to know that B has bought the house for himself, he, Mr. A, can compel him to sell it to A at the price he gave for it. So this is where he has the right to claim the benefit. The next duty is that he is not supposed to make any secret profit. So agent is in a fiduciary capacity to the principal, just the way director is sitting in a fiduciary capacity to the company. Similarly, agent is in a fiduciary capacity to the principal. And if he is not supposed to make any secret profits and always has to act in good faith. Next is to render proper accounts. So whatever detailings of the account is there, he always has to give it to the principal whenever he is asked for it. Second, he is not supposed to delegate because lawfully delegation by a delegate is not permitted. Pay the sums received from principal. So whatever amount agent receives on behalf of principal, that same amount has to be given to the principal. Second, duty not to use any confidential information that is received in the course of agency. So whatever information agent receives during his principal-agent relationship, he cannot later on use it against the principal. So these were all the duties of the agent. Are we good on this? So we will quickly repeat the duties of an agent. 1, execute the mandate. 2nd, follow instructions or customs of the trade. 3rd, exercise reasonable care and skill. Fourth, communicate with the principal. Fifth, avoid conflict of interest. Sixth, not to make secret profits. Seventh, render proper accounts. Eighth, not to delegate. Ninth, pay some receipt for the principal. And 10th, not to use any confidential information against the principal. So these are all the duties of the agent. Now, because the agent has duties, he also has certain rights. What are the rights that an agent has? Correct? So now we will be discussing rights of an agent one by one. Are we good till here? Any confusion till here? Now, the first right of the agent is to retain out of sums received on principal account. So what is this right? He can keep some money for himself. The money that he has received on behalf of the principal, he can retain some amount out of it. What are these amounts that he can retain? So section 217 says that the agent has a right to retain out of any sums received on account of principal in the business of agency for the following payments. 1. All money due to himself in respect of advances made, in respect of expenses properly incurred by him in conducting such business, such remuneration as may be payable to him for acting as agent. So these are the amounts that he can retain for himself. The expenses that he has incurred in conducting business, the remuneration that is due to him, and the advances that he would have made. So the money that is due to him for the advances that he has made, all these money he can retain out of it. So what it means here, it is not necessary that if the agent has received rupees 10, he has to return entirely rupees 10. If rupees 2 is due to the agent, he can keep rupees 2 for himself and pass remaining rupees 8 to the principal. But obviously, he will have to give the accounts to the principal. He will have to tell the principal on what account he has retained those amounts. Is that clear? The next is the right to remuneration. So, remuneration is also permitted to the agent. He has a right to receive the remuneration for the work that he has done. But if the agent is guilty of a misconduct in the business of agency, he will not receive remuneration for the part of the business where he has misconducted himself. Correct? So generally he has a right to remuneration, but where he has done where he is guilty of misconduct, he does not have a right of remuneration. Next is agent's lien on principal property. What is the lien? What is meant by lien? Can somebody tell me? We have already discussed that in previous class. Namrata, your query on sub-agent, I will take it up again at the end of the class. In the middle of this topic, I will not start with the concept of sub-agent. We will discuss it again. Don't worry. Okay. Can somebody tell me what is the right of lien? I'm waiting for your answers. What is the right of lien? Yes. Okay. So right to hold back the property till the remuneration is received, that particular property. So section 221 says, in the absence of any contract to the contrary, an agent is entitled to retain the goods, papers, and other property, whether movable or immovable, of the principal received by him until the amount due to himself for commission and disbursement of and the services has been paid or accounted for him. But if you pay attention to 21, it says, in the absence of any contract to the contrary. So where there is a contract between a principal and agent which specifically omits the right to lien, that is the exception. Else, agent has a right to retain the goods, papers, properties, movable or immovable, until the amount that is due to himself for commission has been paid or accounted for. Correct? But to be able to exercise the right of lien, there are few conditions that need to be fulfilled. Firstly, agent should be lawfully entitled to receive from the principal a sum of money for the services he has rendered. The property over which he is exercising the right of lien, it should belong to the principal and should have been received by the agent in his capacity during the course of his duties as agent. And third thing is that he has only a particular lien. That means particular good for that particular service. So when we say that the tailor has a right to particular lien, he can retain the shirt for the stitching cost of that particular shirt. Not some other dress he can retain for the stitching cost of shirt. So he has a right of particular lien. Always remember the difference between general lien and particular lien. We have already discussed that in detail in the previous classes. However, there can be situations where the agent's right to lien is lost. So the first situation is where the possession of the property is lost. Second, where the agent waives off his right in the agreement, or there is a terms of conditions of agreement which takes away the right of agent's right of lien. Is that clear? Are we good till here? Any confusion till here? Please tell me. Next right of an agent is the right to indemnity. What is meant by indemnity? What is meant by the word indemnity? Can I have answers, please? What is meant by right to indemnity? So indemnity is to make good the loss, correct? So an agent, because he is acting on behalf of the principal, he has a right to be indemnified for all the consequences of lawful acts that has been done by him in exercise of his authority. So whatever is done by the agent lawfully and within his authority, he needs to be indemnified for the same. So if you look at this example, A of Delhi appoints B of Mumbai as agent to sell his merchandise. As a result, B contracts to deliver the merchandise to various parties. But A fails to send the merchandise to B, and B faces litigation for non-performance of contract. So here A will be bound to protect B against the litigation and cost. Okay. Also, he not only has a right of indemnification for lawful acts, he also has a right for indemnification for things done in good faith. So whenever agent is acting in good faith on the instructions of the principal, he is entitled for indemnification. So if you read here, P appoints A as his agent and directs him to sell certain goods which in fact turned out to be not belonging to P. And third parties sue the agent. So here the agent will have to be indemnified because he acted in good faith. Next is non-liability of employer of agent to do a criminal act. So where a principal appoints an agent to do something criminal or illegal, he will not be liable to the agent, whether it is an express promise, implied promise, whatever it is, there is no right to indemnify them. So indemnification is always seen only in the legal lawful acts. This is something that we have already discussed when we were talking about contract of indemnity. Correct? Next right of an agent is the right to compensation for injury caused by principal's neglect. So whenever there is some loss that has been suffered by agent because of the neglect of the principal or want of skill, in that case, he has to be compensated. So if you look at this example, A employs B as a bricklayer in building a house and puts up the scaffolding himself. The scaffolding is unskillfully put up and B is hurt. So here B will have to be compensated. Is this clear? So duties and rights of an agent is clear to all of you? So summing up the rights of an agent, what are the rights of an agent? One is right to remuneration. Second is right to retain out of sums received on principal's account, right to lien, right to indemnification, right? And is that clear? And right to compensation for the injury that is caused by principal's neglect. So with this, we complete the topic, which is duties and rights of an agent. Now, the next topic that we have to take up in the contract of agency is the principal's liability to third parties. What are the liabilities of the principal in a contract of agency towards the third party? So everything that is done by the agent, it is done on behalf of the principal, and it is supposed to be an act done by the principal himself. So the principal is primarily liable to the third party for all the acts of the agent. Is that clear? So an agent does all acts on behalf of the principal but incurs no personal liability. There is no liability of agent towards the third party. Agent is liable to the principal, but the principal is liable to the third party. Is that clear? Now, the first liability is for the acts of the agent. So section 226 says, principal is liable for the act of agent which are within the scope of his authority. Correct? So wherever the agent is acting within the scope of his authority, principal will be liable for the act of agent. Now, can there be exceptions or another situation here? Supposedly, the agent acts out of the authority, correct? Can, in this case, principal be held liable? Yes, he can be held liable where there is either a ratification by the principal or there is a agency by estoppel. So always correlate the concepts. Okay. So generally section 226 says that principal is liable for the act of agent which are within the scope. Contracts entered into through an agent and obligation arising from acts done by an agent may be enforced in the same manner as if they had been entered into by the principal himself. So anything which is done by the agent on behalf of the principal, it is deemed as if it was done by the principal himself. Right? Section 227 talks about situation where principal is not bound when agent exceeds authority. So if agent does something which is beyond the scope of his authority, in that case, the principal will not be bound. But where this acting beyond the scope is not separable, that case, what will happen? So section 227 says, when an agent does more than he is authorized to do, and when the part of what he does, which is within his authority, can be separated from the part which is beyond his authority, So much only of what he does as is within his authority is binding between him and principal. So we are talking about a situation. There are actions taken by the agent. Some is within the authority, some is outside the authority. But with authority and without authority is separable. If it is separable, the principal will be bound only by the actions that are taken by the agent that were within the authority. For this part which was beyond the authority, he will not be held bound. But the key requirement is that authority part and without authority part should be separable. It could be clearly demarcated. Correct? So if you look at this example here, A, being owner of a ship and cargo, authorizes B to procure an insurance for rupees 4 lakh on the ship. B procures a policy for 4 lakh on the ship and another for the like sum on the cargo. So not only he procures the insurance for the ship, he procures the insurance for the cargo as well. So here A will be bound to pay the premium of policy but not the premium for the cargo. Now what has happened here? These were two actions that were separable. The action that was within authority was to purchase insurance for ship. Purchasing insurance for cargo was not in the authority. So the principal will be liable for anything which was done in the authority and not outside of the authority. But this is the situation when the authority is separable. What happens if the authorized act and unauthorized act is not separable? In that case, what will happen? In that case, principal is not bound to recognize the entire transaction. So if you look at this example, A authorizes B to buy 500 sheep for him. B buys 500 sheep and 200 lambs for one sum of 6 lakh rupees. Okay, so we do not know what is the price of sheep. We do not know what is the price of lamb. There is a clubbed price of total 6 lakh rupees. So in that case, he can repudiate the whole transaction. So where the transaction is separable, he is liable only for the authorized transaction. Where the authorized and unauthorized transaction is not separable, he can repudiate the whole transaction. Is that clear? 227 and 228 is clear. Any confusion here? However, there is an exception to this. The exception is where principal, through his actions or conduct, has made or induced the third party to believe that the agent's unauthorized act were authorized. So what is happening here? Agency of Estoppel comes into picture. So where through his conduct he has made the other party to believe that the acts were authorized. In that case, principal will be bound by such act or obligation. But for that, he should have induced the third person to believe that such actions were within the scope. So the exception to 227 and 228 is the agency to Estoppel. Is that clear? Now, what is the consequence when the notice is given to the agent? Supposedly, I have appointed Mr. C to take care of my business in Mumbai. I am resident in Delhi. Now, let's say a notice for check bounce is given to Mr. C, who is my agent in Mumbai. So, even though I have not directly received the notice, but Mr. C, being my agent, has received the notice for the business, it will be considered that the notice was duly served to me and I will be held liable. This is what is given in 229. So section 229 says, any notice given to or information obtained by the agent, provided it be given or obtained in the course of the business transacted by him for the principal, shall, as between the principal and third parties, have the same legal consequence as as if it had been given to or obtained by the principal. So the principal cannot take the defense that he had no notice. If the notice has been duly served, if the information has been duly provided to the agent, it will have the impact that it was given to the principal himself. This is what is given in section 229. So if you look at this example here, A is employed by B to buy from C certain goods of which C is the apparent owner and buy them accordingly. In the course of the treaty for sale, A learns that goods really belong to D, but B is ignorant of the fact. So here, B will not be entitled to set of debt owing to him from C against the price of good. So this is how this functions. Next is principal's liability for agent fraud, misrepresentation, or torts. What happens when the agent is acting fraudulently, or he has made representation, or he has done some sort of torts which are civil wrongs? Okay. So section 238 says misrepresentations made, frauds committed by agents acting in the course of their business for their principal have the same effect on agreement made by such agent as if such misrepresentation has been made committed by the principal himself. So where misrepresentation or fraud is committed by the agent, in the due course of business, it will be treated as if the fraud or misrepresentation was made by the principal himself. But misrepresentation or frauds done for areas which were not within his authority, in that case, principal will not be liable for such action. Principal will not incur any liability for same. So anything that agent does, if he does it right or he does it wrong, the principal stands liable to third party. The only exception being that the agent is acting beyond the scope of his authority. Whenever there is beyond the scope of authority, the exception that comes into picture is the agency by Estoppel, where there is a representation or inducement. Is that clear? Is this clear? This section is clear? Any confusion in this section, section 238? So if you look at this example here, A being B's agent for the sale of goods induces C to buy them by a misrepresentation which he was not authorized by B to make. So here the contract is voidable between B and C at the option of C. A, the captain of B's ship, signs bill of lading without having received on board the goods mentioned therein. The bills of lading are void as between B and the pretended consignor. So if it is beyond the authority, it can be voidable. Next is section 230, which talks about so section 230 says, it talks about agent's right to enforcement. So agent cannot personally enforce or be bound by contracts on behalf of principal. So there is no personal liability of agent as such. So if you see, section 230 says, in the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor is he personally bound by them. He can neither sue nor be sued on contracts made by him on his principal's behalf. So whenever an agent is entering into a contract on the behalf of the principal, he cannot enforce that contract. Enforcement will have to come from the principal himself. He cannot be sued or can sue or be sued on those contracts. However, there can be certain exceptions. The exception says in those exceptional cases, agent is presumed to have agreed to be personally bound. So as such, generally there is no personal liability of agent. It is always the liability of the principal. But there can be exceptional cases where the agent is presumed to be personally bound. So what are those exceptional situations that we will be discussing now? So the first situation is where the contract is made by an agent for the sale or purchase of goods for a merchant who is resident abroad or foreign principal. So where the principal is such that he is a foreign body or is a individual who lives abroad, in that case, agent can be held to be personally bound. So when an agent has entered into a contract for the sale or purchase of goods on behalf of a principal who is resident abroad, the presumption is that the agent undertakes to be personally liable for the performance of such contract. He will be liable for the performance. So this is the exceptional circumstance where he can be held to be personally liable. So I am repeating, general principle, agent can neither enforce the contract nor can he be held personally liable, correct? But there can be exceptions. The first exception is where the agent has entered into a contract for sale or purchase of goods and the principal here is a abroad citizen or he is resident abroad. In that case, agent can held to be personal liable for the enforcement of contract or for the performance of contract. Second situation is agent does not disclose the name of his principal. So where the agent does not disclose the name of the principal, then it is assumed that he undertakes to be personally liable. Correct? So in this case, the principal cannot be sued. The third exception is non-existent or incompetent principal. So where the principal, even though his name has been disclosed, he cannot be sued. In that case, agent will held to be liable. For example, agent who contracts for a minor. So in this case, the minor can never be held liable. It will be the agent who will be made personally liable. Right? Is that clear? Is that clear? Next is the pretended agent. So where the person is actually not an agent, but he pretends to be an agent and the actions that were done by him is not ratified by the principal. The principal disowns the actions of the agent. In that case, the agent will stand liable, will stand personally liable. And next situation is where the agent exceeds authority. So wherever the agent exceeds his authority and he misleads the third party to believe that he has the requisite authority, in that case also he can be made personally liable. So these were the 5 exceptions where the agent can be made personally liable. One, he enters into a contract for the principal who is resident abroad. Second, he does not disclose the name of principal. Third, he discloses the name of the principal, but the principal is incompetent. Fourth, he pretends to be an agent and his actions are not ratified by the principal. Fifth, where he exceeds the authority. Under all these 5 circumstances, the agent can be held to be personally liable. So I'm repeating, general principle, agent is not personally liable. 5 situations of exceptions where they can be held to be personally liable. Correct? Are we good till here? Any confusion? Are we good till here, guys? The next section that we take up is contracts that have been made without disclosure of agency. So what are the rights of a parties to a contract where they have been made, a contract has been made by the agent without the disclosure of an agency. So section 231 says, if an agent makes a contract with a person who he neither knows nor has reason to suspect that he is an agent. So what is happening? Agent is entering into a contract with this person. This person, he does not know that whether he is an agent or that he is not an agent, or he has any reason to suspect that this fellow is not an agent. In this case, principal may require the performance of the contract, but the other contracting party has, as against the principal, the same right as he would have had as against the agent if the agent had been the principal. So what is happening here? Here this third party is having the same right against the agent if the agent was the principal. So what's happening? This person is the agent. He is entering into contract as if this person was the, closes himself before the contract is completed. The other contracting party may refuse to fulfill the contract. If this party gets to know that this person is the agent or he is not the principal, he may refuse to enter into the, correct? If he can show that, do that. This is what is given in section 231. Next is section 232, which talks about performance of contract with agent supposed to be principal. Correct? So where one man makes a contract with another, neither knowing or having the reasonable to suspect that the other is an agent, the principal, if he requires the performance of the contract, can only obtain such performance subject to the rights and obligations subsisting between the agent and the other party to the contract. So let's look at this example here first, then I will explain 232. A, who owns 50,000 rupees to B, sells 1 lakh worth of rice to B. So what is happening? A owns 50,000 to B, correct? Sells rice of rupees 1 lakh rupees to B. A is acting as an agent for C in the transaction, but B does not know that A is the agent of C, correct? And neither he has any reasons to suspect that he is the agent. In that case, C cannot compel B to take the rice without allowing to set off A's debt. In that case, what's happening here? C cannot compel him to take the rice and pay full 1 lakh rupees. He will have to honor the obligations, whatever were there between the agent and the third party. So, we are talking about a situation where agent enters into a contract with third party. This third party does not know that he has an agent. So, principal will have to perform the contract that has been entered into between agent and third party, subject to the rights and obligation between agent and the third party. This is what is provided for in section 232. Is this clear? 232 is good with all of you? Next is section 233, which talks about cases where the agent is personally liable. So, 233 says, in cases where the agent is personally liable, we have discussed those situations, a person dealing with him may hold either him or principal or both of them liable. So where the agent becomes personally liable, the third party has a right against the principal and agent both. This is what 233 says. So if you look at this example, A enters into a contract with B to sell him 100 bales of cotton and afterwards discovers B was acting as an agent for C. In this case, he can sue either B or C or both for the price of cotton. So even though agent was acting beyond his authority or he was personally liable, in that case also third party has a right to sue either of them or both of them. Correct? Next section is section 234, which talks about consequences of inducing agent or principal to act on belief that principal or agent will be held exclusively liable. So here 234 says, when a person who has made a contract with an agent induces the agent to act upon the belief that the principal only will be held liable, or induces to principal to act upon the belief that the agent only will be held liable, cannot later on hold liable agent or principal respectively. So again, estoppel is happening. You are making one party to believe that only either of them will be held liable. In that case, you cannot go back on that. So these were all about consequences of entering into a contract without disclosure of agency. So there were different situations that we have discussed here. The next topic is revocation of authority, which I will not take up today because it's already now 9:25 now. We also have one more faculty with us, which is Shraddha ma'am, who would like to discuss with you general methods of preparation for your exams and how do you have to handle queries, right? Questions in the examination paper. So I will hand over the class to her to discuss with you general principles of general methods of preparation for exam. The topic that is left behind, which is revocation of authority, I will take up in the next class, which I have with you on 27th Feb. So first I will complete with the revocation of authority and only then I will start with the GCI. Also, whatever queries that students have that have not been able to discuss, like one of the student requested me to discuss section 229, one requested for a difference between section 231 and 232. I will discuss all the queries in the next class. Okay. Now I hand it over to the Shraddha ma'am from the BOS, the Board of Studies, who will take up with the remaining part of the class talking about the general preparation for examination. Over to you, ma'am.
Very good morning to dear students and a very good morning to Sonali. Sonali is a very affluent speaker and I have seen the comments that all the queries that she has answered and all the students appreciating you. So it was indeed a very nice session, Sonali. Am I audible?
Thank you, ma'am. Yes, you are audible.
Yeah. So, dear students, as you know that our May 2022 examinations are bound to happen in some time, and only most probably, if we count the number of days, they would be hardly 60 or something. So approximately 2 months, March and April are left. Feb, I'm now counting since we are today we are standing on 20th February. So only 8 days are left. I hope you all have attended the virtual classes very diligently. This initiative by the Board of Studies is very commendable and students have benefited a lot from this. Coming back to our topic that how we should prepare for the examinations, by now you must have prepared, must have studied the subject twice or thrice. And with the help of the LVC, the virtual classes faculties, you can once read the subject while they are teaching you. And then these are uploaded on ICAI YouTube also. So you can again go through them. How to prepare for the examination is a different topic altogether than how to prepare yourself for the examination. These are two very different things. We know that the paper 2 that we are talking about, corporate and other laws, is divided into 2 portions. One is the Companies Act 2013, which is for 60 marks. And the other is other laws portion, which is for 40 marks. Which is for 40 marks. So going by that, we know that the bifurcation is of 60:40. But when the paper comes, if you see the paper is divided in the ratio of 30:70, which is, there are two divisions in the paper. One is division A, which comprises of the MCQs. And the other is division B, which is descriptive questions. Division A comprises then again of two things. Basically, it's MCQ based, that one are case scenario based MCQs and the other is independent MCQs. In the case scenario portion, there is a case scenario. There can be one or there can be two case scenarios. One case scenario can be from the Companies Act portion, and the other can also be from the Companies Act portion, but it can also be from the other laws portion. So students who do not give much importance to the other laws portion, I would request you to give equal importance to both the portions, as you need to pass it with flying colors. So the MCQ portion, which is of 30 marks, is divided into case scenario portion basis, where a case scenario will be given and it will be followed by a few MCQs which will be deriving out of those case scenarios. So while answering those MCQs, you should be very careful that don't answer them just generally. Do read it in conjunction with the case scenario. Then the second part is your independent MCQs. Independent MCQs, it will be a short question and followed by it's a normal multiple choice question. But always correlate the facts and the options given. You have to mark those options in the OMR sheet that has been given to you. Mark only one answer as correct. Sometimes students feel that more than one answer is correct. If you're damn sure about it, do mark it. But if you're not sure about it and you mark two answers just like that, you will not fetch any mark. It is better to mark only and only one answer in the OMR sheet. And there is only one correct option. Mark the answer which you feel is most appropriate. Sometimes students do get confused, that they feel, oh, this answer is not correct, that answer is not correct, we are not getting any answer as correct. Then also apply your mind and mark the answer that you feel is most appropriate. Because when the questions are given to you, they have an answer. Then apart from that, there is no negative marking. And you have to keep in mind that this 30 marks portion is compulsory. The MCQs portion is compulsory for the students. They have to necessarily attempt it. And then coming on to the rest portion, coming on to the next portion, which is of 70 marks, which is your descriptive question. Descriptive question, just hold on. Yeah, the descriptive portion is of 70 marks. Descriptive portion again is divided into two parts. Rather, let me say that it's generally 5 questions. Question 1 is compulsory, and the rest 4 questions, that is question 2 to 5. The student has to attempt any 3 questions out of these 4 questions. Then going on further, the basic question that all the students ask us. So before answering that, how we should attempt or how we should answer a particular type of question, do keep in mind that the September 2021 edition of the study material is applicable for you. It is uploaded on the website, and also it is available on the CDS portal. Then the RTP will be available to you in due course of time. It will contain questions as well as the necessary amendments. September 2021 edition is updated till 30th April 2021. So the 6 months amendment, that is 1st May 2021 to 31st of October 2021, will be given to you through RTP. And they are very much applicable for the May 2022 examinations. Then going on further, a journal question that we get to know is how we should answer the descriptive question. Do we write word to word, or we can write it in our own words? The descriptive questions have to be answered by writing the first, read the question, pick out what is the issue and what is the relevant provision. Write that while answering the question, write the relevant provision, and then facts of the question, and then the conclusion. Sometimes the question is such that if you write the facts of the question separately, it will take up unnecessary time and there is no need. Then what you can do, write the legal provision, and then by correlating the facts of the question, write the conclusion. That is the basic of answering any kind of question, legal issues involving question. And while we were into this session, ma'am was saying, Sonali was saying some questions that this topic is important, that topic is important. Dear students, the topics are all the topics are important. When any teacher tells you that this topic is important, it is important for you to understand this topic. It is very important for you because students might be faltering too much in that topic. But from the examination point of view, read each and everything. Don't ever do selective studies. Keep on reading and understanding and practicing, because if you do selective study, you might have seen the past question papers. You can easily see that the institute is now asking you questions from each nook and corner. They are not leaving any topic that can be covered during the examinations. So I will be just seeing if any one of you has asked any query to me. Just hold on. A student, Miss Gajjar Naveen Chandra has asked, ma'am, in MCQ we have negative marking like foundation. No, dear student, there is no negative marking. And as far as we know, students do face one more question. Do we need to write word to word of the legal provision? It is practically not possible for anyone to write those answers. That to write each and every word the way lawmaker has given it. It is not practically possible. However, when you keep on reading the law again and again, it directly flows into your blood. It's not only with the corporate and other laws, be it any law-based subject. If you keep on reading it, you will see that after some times, you get to know that a provision is there. You know it's starting with notwithstanding this. You get to know the feel of the section. Many students understand the gist of the section, but while writing the answers, they are not able to write it in a legible manner. Legible not only means that you have to write it in a good handwriting. Handwriting matters, but the way you present the answer is also very important. Writing section number is not that important. However, writing the keywords of the section, writing the keywords of the legal provision is very important for you. Just writing in your own words do matter, but while writing the answer in your own words, it is very important for you to take the crux out of the legal provision. And once you have reread that provision again and again, definitely you will be able to write it. And you will not feel the problem that, oh, I don't know how to write the legal language. Legal language is not that difficult if we have the right preparation. You don't need to ratify the provision. But the line will be very wrong if I see once. If you keep on reading the sections again and again, you will definitely get to know the rhythm of the section and the words used in the sections, which are the keywords of the section. And that does make an impression while you are writing the answer. Don't take it just as an exam from the examination point of view. Take it from your personal growth point of view. Once you have cleared the CA examination at intermediate level, you will start preparing for your final level. It is the professional course. And while doing your articleship, you must have seen people who might have cleared one group and they have enrolled themselves for the articleship. So people who are doing their articleship or who are about to do their articleship, you can definitely see that while you are making your papers, working papers for your principal, it does make a difference when you are writing a good language. So if you have any query apart from this, do let me know. Okay, so I have, ma'am. So ma'am, when will the test series start? We will be uploading the schedule of test series I think by a week or so. Then there is another question, ma'am, does the fact of the case carry dedicated marks? I think you want to ask that whether writing the facts of the question will fetch marks, or is there are dedicated marks for that? No. As such, why will the institute give you marks for writing the question that they have given it? However, that's why I said that instead of writing the facts of the case altogether, if there is time constraint, you may combine the facts of the question and the conclusion. But as a good practice, the legal provision, then the facts of the case, then a correlation between the facts of the case and the conclusion. However, in the paucity of time, and if you feel that it is unnecessary to again repeat the facts, then you may directly conclude the answer by correlating it with the facts of the question. Like in the given question, since the situation is this, hence the conclusion. So you can write it like that. Then, ma'am, how to practice descriptive questions? Namrata, the thing is that first of all, keep on reading the legal provision. Do make your short notes. And for the short notes, even if you see, like we have done this chapter, you can see the capsule. We already have the short notes, the capsule of Feb 2020, the capsule is there in the Feb 2022 edition of this Students' Journal. So you can see this contract act from there. The notes are already provided. You can update them according to yourself. And the way we have prepared the capsule, in the similar manner, do prepare notes for yourself also. And while you are saying that how to do the descriptive question, practice for the descriptive questions, you can simply keep the questions that are given at the back of the module, the study module. Then we have the RTP. Just a moment. I'm sorry. Okay, sorry. Can you see me now? Now it's fine? Yeah. So, sorry, students. So, the questions are there at the back of the module. Then the RTP is there. Then the mock test papers are there. So you can do it from that. and you can definitely prepare the descriptive questions from it. So I will be taking some more queries only, as I think students the time is there, already getting over. How to manage revision in both parts of paper in timely conclusions. I'm sorry, I did not get this question, what you are trying to ask. Ma'am, I am giving both groups. Ma'am, we got our foundation results in September. Ma'am, we got only 6 months. Why in May? Now what to do? Is my decision right to give both groups? Students, like these kind of questions, you can just post them on the query pad of the BOS app, and we will definitely get back to you. Due to paucity of time, I will not be in a position to answer many questions, all the questions, but there I will definitely answer. But I will just answer this question, how to prepare for case study question. The case study questions are what? They are a bigger portion, like the normal question you get, but in the case scenario, you have the full page is there, and then you answer the question. When you read the case study, just keep in mind that what all are the important points in that case study. Then read the MCQs. When you read those MCQs, just go back to the case scenario that is given. And if you see, we have already a booklet of case scenarios and independent MCQ that is already uploaded on the website. A booklet of case scenario based question is already uploaded on the website. Do read it from there. We have 40 case scenarios there. So I think those are more than enough for you. You can definitely prepare from there. There is one more question. Can we prepare figures or charts in exam? No. You have to write in proper language. This mistake many students are doing while they are preparing the examination. We do tell the students that you have to make charts, you have to make short notes, but that is for you to understand, and that is for you to revise it just a day before the examination. Those are for your revision. Those are not for the revision of the paper checker. So I request all of you students, in order to fetch good marks, start writing properly. English, if you have opted for English language or you have opted for Hindi language, write in proper line sentences. Do not write, like I have seen many a time students come to us and say, I wrote you. Why, instead of writing Y or U, students say that I wrote U, simple, a capital letter U. I said that will not suffice in the examination. Though that has become the culture right now in WhatsApp and messages, but please request you to write it in proper language. Don't opt for these shortcuts. Would you like that? Would you do the same with your client? No. If the answer is no for you, then please don't do it in the examinations also. The paper checker will not see to it. He will, or he or she, whosoever is checking your paper, will have to check it in the proper English language. I will just take one more query. Okay. One more student have asked, like this is a query that many a times we ask this query, that I wrote everything, but I did not get marks. Writing everything as per you, but when you check it with a teacher, just see, have you written it in a proper language, in a proper manner? Just think, when you are attempting that paper, think that the person who is writing that paper, though he has the knowledge, but you have to communicate whatever you understand to that person. Just don't think that since the person is knowledgeable, they will try to get the essence of what you are writing. No, try to write it in a proper language, write it word to word. Don't depend on charts. You have to write the answer in points. Many a times, like there are full descriptive questions, which are knowledge and comprehension based question. You can write it in points, but writing just a single word will not suffice the purpose. They are for your revision. They are not for a person to understand that what is your understanding of that provision, or what is your understanding of the crux of whatever you have read. So this was about a journal preparation for the examinations, or rather I should say journal preparation for how to study this subject. If there are any more queries, you can post them to our query pad, which is on the BOS app. Hope this session has helped you in understanding how to go about it. Do visit the ICAI website regularly, and you will get all the information, the latest updates that are applicable for you there. And do download the BOS Mobile App. It's a very handy app, and everything is there, whatever you need. Looking forward for all of you to pass your examinations. First prepare and then pass your examinations with flying colors. Have a nice day and happy preparation. Thank you. And thank you, Sonali, also.
Thank you, everyone, for your time and patience. I think we are done for today. And yes, I am very well aware that we have not completed the contract of agency. The revocation of authority part has been left, which I will be taking up in the next class, which is scheduled for 27th February. So first I'll complete revocation of agency, and then I'll start with GC Act. So all of the students who have been present in the class today, I would request them to be present in the next class also. And also the queries that I could not take up, you can go through the topics that we have discussed today. Prepare your queries in the morning when we start our class. Immediately after completing revocation of authority, we'll take your queries one by one, and then I will start with General Process Act. So with this, we finish our class for today. All of you, till then, take care, stay safe, and prepare well. All the best for your preparation. Thank you. Yes.